This court in Haricharan case within bracket AIR 1964 Supreme Court 1184, further observed that section 30 merely enables the court to take the confession into account. Stop. It is not obligatory on the court to take the confession into account. Stop. Where the prosecution relies upon the confession of one accused against another, the proper approach is to consider the other evidence against such an accused, and if the said evidence appears to be satisfactory and the court is inclined to hold that the said evidence may sustain the charge framed against the said accused, the court turns to the confession with a view to assuring itself that the conclusion which it is inclined to draw from the other evidence is right. Stop. The court in Haricharan case, clarified that though confession may be regarded as evidence in generic sense because of the provisions of section 30 of the Evidence Act, the fact remains that it is not evidence as defined in section 3 of the Evidence Act. Stop. Therefore, in dealing with a case against an accused, the court cannot start with the confession of a co-accused, it must begin with other evidence adduced by the prosecution, and after it has formed its opinion with regard to the confession of a co-accused, it will be another evidence adduced by the prosecution, and after it has formed its opinion with regard to the quality and effect of the said evidence, then it is permissible to turn to the confession in order to receive assurance to the conclusion of guilt which the judicial mind is about to reach on the said other evidence. Stop. Thus, extrajudicial confession that is suffered by the accused is a sword of blow that is hanging over his head, as the same with the corroboration of the evidence presented to the court by the prosecution can prove to be the last nail in the coffin, and if not corroborated and found to be the one inspiring confidence, can be discarded altogether, given the nature and volatility of such a confession. The courts over the years, the apex court and the high courts across the country have established guidelines which have to be followed before accepting such a confession into evidence and ultimately use it for conviction of the accused. Stop. In Sahadevan versus State of Tamil Nadu within bracket 2012 6 SCC 403, the apex court called out certain principles regarding the reliability of an extrajudicial confession which have also been relied upon in a catena of decisions. Stop. The principles as stated in Sahadevan within bracket Supra are produced below. Stop. Para. Upon a proper analysis of the above referred judgments of this court, it will be appropriate to state the principles which would make an extrajudicial confession an admissible piece of evidence capable of forming the basis of conviction of an accused. Stop. These precepts would guide the judicial mind while dealing with the veracity of cases where the prosecution heavily relies upon an extrajudicial confession alleged to have been made by the accused. Stop. Para. The extrajudicial confession is a weak evidence by itself. Stop. It has to be examined by the court with greater care and caution. Stop. It should be made voluntarily and should be truthful. Stop. It should inspire confidence. Stop. An extrajudicial confession attains greater credibility and evidentiary value if it is supported by a chain of cogent circumstances and is further corroborated by other prosecution evidence. Stop. For an extrajudicial confession to be the basis of conviction, it should not suffer from any material discrepancies and inherent improbabilities. Stop. Such statement essentially has to be proved like any other fact and in accordance with law. Stop. Keeping all these facts in mind, recently Supreme Court in the case of Prabhat Bhai versus State of Gujarat 2023, have examined the importance of the quality of evidence, particularly in cases where extrajudicial confession has been taken into account as evidence, most especially in a murder case. Stop. The apex court acquitted the convict while emphasizing the fact that for extrajudicial confession to be considered as evidence against the accused, the same should be of sterling quality and should be in line with the chain of evidence produced before the court. Stop. The Honorable Court, while acquitting the convict, observed that normally any accused person would make a confessional statement before a person in whom he has complete faith, which is an important and relevant fact while determining the evidentiary value of the confession made for reaching to the conclusion of conviction. Stop. For evidence that is of the nature of extrajudicial confession, one has to be very careful and there cannot be any scope for doubt, as the court should be instilled with the utmost confidence to accept the most and same on its face value alone. Stop.